Look, I have one provision to read, is section 12A, which has a power. First, I can take you to the recognition order, which is at page 130.
130
of the Nandan Singh's paper book. Nandan Singh SLP.
State SFL.
State SLP, sorry. Look, 131 is the relevant. Para 2 on, I will just read. And whereas in view, well, are there, at page 131, the recognition order by NCTE for this LOD sportsman. 131 is a relevant para sec 2. It starts at and whereas in view of the above mentioned direction of the Ministry of Human Resource Development under section 29 of the NCTE Act and after considering after considering recommendations of expert committee, after considering all recommendation of expert committee, chairperson of NCTE exercise of his power under clause 12 of the NCTE recognition norm and procedure regulation 2014 granted relaxation by NCTE headquarters letter dated so and so to the following provisions in the NCTE regulation 2014 for ensuring that the directives of the MHRD for implementing the amendment to the RTE Act 2019 are duly fulfilled. In that, my lords, the second one is important. Any provision related to the duration of the program.
So this has to be read with reference to the directions of the MHRD.
Yes.
And the directions of MHRD are for a specific purpose. So as to provide a window to the persons who are already in employment and that they don't get out of employment by 31st of March 2019.
Yes.
So it will have to be read in that context. It can't be read in isolation.
Bow down, my lords. What has happened since we reduced that pause to 18 months and provided it online and duly recognized, many states offered that, many people appeared for that. And that's where the problem started and everybody approached the different high courts. So Patna High Court and Tripura High Court allowed them to do so. And those orders were not challenged. That's been the stand of NCTE.
On the contrary, NCTE should have challenged those orders.
They had not, unfortunately.
Yeah, it's unfortunate. How could a relaxation for a specific purpose be used to give them equal status?
No, because they were in service experience.
So in service for the limited purpose of protecting their service.
Absolutely. I'm not arguing on that.
The MHR direction, the HRD direction is only with that regard.
I bow down. That's the only limited submission I have. I do not want to waste court's time.
Thank you.
I'll just take 5 minutes just for your lordships to consider the...
You are appearing for?
I am appearing for the impleaded parties. We were in the writ petition ourselves, but we were not made parties here.
Impleaded parties means we are or 18 months or 18 months.
To be clear, we had 18 months, people in private service, and we are arguing that we should be allowed to apply.
Mm-hmm.
Your lordships have repeatedly said, and I think we can't go beyond that, your lordships have said that the power, I implied at least in what your lordships are saying, that the power to relax is there. And the power to relax on the basis of what the government of India has said, that power has been exercised. But as your lordship said, for a limited purpose. These were people in service. They should not be knocked out of service because there was a limited time within which your lordships have rightly said. That your jobs should be secure. You should not be thrown out of a job overnight. Well, the limited purpose may well be achieved, but it's achieved because your lordships are recognizing the right to relax, etc., or the duty to relax. Well, what happens with us is we don't lose our job, but it's only once that this exception was being made. It was not for all times to come. So it was only being made now for us. We will retain our jobs but we will not have the right to apply to get into a better job, i.e. a government job. Well, for that, I'm only seeking your lordships to consider whether a purposive interpretation of that document can be done as to what is the indication for power to relax. Is it to put you on power, which some reading might suggest that you're on par with the 2-year course, or it is only specifically, as your lordships have said, to protect you in your jobs. And my lords, considering the fact, as your lordships have observed, that the orders of the 2 high courts were not challenged, and they were proceeded with in the manner in which we are trying to argue we should have been proceeded with, and the High Court in Uttarakhand has in fact proceeded with it. My lords, that would create 2 classes of people, one who have this on par with the 2-year course, and one who will be, if your lordships go against us, would not be on par with the 2-year course. So, my lords, I'm only seeking that your lordships look at it purposively to see that this was not a permanent solution. It was just a solution for a specific time and place where there was no way that we could have been told to go and do a 2-year course because the time was not available. Retrospective application.
Specific purpose.
What is the purpose? Your purpose, your lordship.
Specific measure for specific purpose.
Well, if your lordships come to that conclusion, then really I can't argue any further that this was limited to the purpose that your job should not be taken away from you. But if it was for the purpose, and I'm asking your lordships or urging your lordships to consider it purposively, that this would amount to implied equivalent to who have a 2-year qualification. If you want to apply, you will be able to apply, etc. Otherwise, we'll have a job for the rest of our lives, but we will never be able to apply. Even in future, we will not be able to apply because we would artificially be put in a little bubble where we have a job, but we have no prospects of going further. Everybody else who are with us, who have been with us, have been teaching with us, have the same experience. If they have the 2-year course, they will go. And that will done. I don't know whether the government will think of another notification where the course by distant education will be made into a 2-year course or not, but it
is already over. That was only for that particular period.
So it was okay. I'm grateful, my lord. It was over. It's now over. There is no proposition now. And being over, it means I will never be able to apply for a job because my equivalence
and that course will not introduced for you. Well, you will be thrown out of the job. Well, and only to protect you in the job, that special window was opened.
Right. Thank you, Manoj. And we are grateful to the government for having done that. So our job, even people who were in the government service who were government teachers who didn't have the qualification would have got the qualification and remain where they were. They will continue as government teachers. But I will not have any further prospects because as far as I'm concerned, your lordship will treat it as one-time solution to leave me in the job, rather than put me on par with anybody else who would apply, selected or get rejected on this purpose. So I will be denied the opportunity of a job. That is the critical matter if your lordship interpreted in one way, and if your lordship interpreted it purposively, then I would be able to apply for the government jobs in future.
How would be purposeful interpretation of the principle of purposeful interpretation applicable?
Well, I'm grateful. All I'm saying is that at that time, when the government gave
on the contrary, if you apply the principle of purposeful interpretation, the interpretation will be against you. The purpose was that the persons are in job, they are without qualification, in view of the RT Act and particularly Section 23 thereof, if they don't acquire the requisite qualification within a particular time, they will be out of job. And with that purpose in mind, the government came out with a special scheme, the object of which was to protect you in your employment.
Well, that's your lordship reading on that document is that this was the limited purpose. But the several documents that Mr. Arora read to you, lordships, they all deal with it in terms of...
Several documents only lead to that conclusion, and it basically emanates from the direction of HRD.
Well, it emanates from the direction of HRD. Direction of the HRD is saying that this is the immediate concern. But in all fairness, my lords, the HRD didn't say that this is our limited concern. that you take care of their job now, no future prospects. This is only for a limited purpose. But as your lordships read, it obviously reads like this is what they were wanting to address. But were they wanting to address it in a manner, I ask myself, that cut off all opportunities for future for me?
That is what document says. The protection in present day would not mean opportunity in future.
Well, I understand. But
There are two different things.
But your lordship will consider that people placed in my position, whether they are in Orissa or they are in Bihar, would be able to apply. They would have already applied, possibly got jobs, and they will apply in future as well. If I have a future opportunity, I still will not be able to apply unless, of course, I resign from my job or take leave and go and work go and do the course for 2 years. I will not have the opportunity.
They have got the opportunity because of a wrong judgment of a high court. We cannot be made to follow that.
Would your lordship hold it against me?
You cannot rely upon a wrong judgment, which according to us, not subject to whatever we decide.
Well, if your lordships come to that conclusion, obviously there is no opportunity. But all I'm saying is that this has no domino effect. This will not be something that concerns people who will come after us. It will be only for a limited persons, only once that this is done, which was the intention of NTCE, NSTCE, but they have unfortunately at that time not thought of that not only should we give them an opportunity to stay in the job, but also provide an equivalence. So what I'm saying is, would your lordships be able to consider, if possible, consider that there's an implied equivalence, if not a specific, explicit equivalence of one course with the other. That, of course, my lords, is an exercise normally which is done where an authority sits down, compares the qualifications, and then comes to a conclusion that this is an equivalent. But in the manner in which this thing has been processed and has proceeded, I would urge your lordships to consider whether there could be implied equivalence for the 18-month online course.
In the absence of minimum qualification regulation for recruitment as teachers, if there would have been no such regulation, probably we may. There is a regulation in place.
For which purpose?
How can we provide for a read implied equivalent which is contrary to the regulation?
Well, but for which purpose? I'm only asking your lordships to look at the Regulation 12. Regulation 12, which gives the power. Regulation 12 that gives the power to exempt.
And we have not heard of any such principle like this implied equivalence.
Well, you haven't, but I'm urging because this seems like a very unique case. That something like this should have.
The unique principle you want us to.
Well, good. Your lordships lay down. Your lordships are developing principles all the time.
Every day. Law is evolving.
Law is evolving.
Or organic.
It's only when your lordships see that there is merit. Your lordship will consider.
We don't want to devolve.
Something like evolve. Because I'm only seeking evolution and not seeking devolution. Well, your lordships develop outstanding jurisprudence when your lordships brought in curative petitions, right? Nobody had heard of, and in fact, world over, nobody has heard of something of that nature, beyond review, beyond reconsideration, etc. But your lordships did, because there may well have been a case that was promising, that was persuasive, and your lordships thought to do justice, let us find a way out, and your lordships have. Similarly, I'm seeking in this case, my lords, to do justice to a case of people who are not in any way responsible for what has happened. Your lordships are saying the judgment of the High Court, which may be wrong, cannot sustain this. But my lords, what chance did I have? I was given an opportunity to go and do an 18-month course. I did the 18-month course. I applied in due course. There was, in fact, an order, the government order of the government, which clearly said that I had a right to apply. They then, of course, on reflection, changed their mind.
We may or may not accept you, but you are in the right track.
Well, I'm grateful that I'm grateful that at least up to this point,
legally probably,
at least up to this point that I've been able to come, and then, well, ultimately, your lordship will look at the fact that this is only one group of people. Their whole life career depends on this. What your lordships will finally decide even if your lordships were to show displeasure in the manner in which...
Only one question.
Well, yes.
You are asking about what will happen to their life. If the NCT would not have come with this window and provided that 18 months course to you, what would have happened to their life on 31st of March 2019?
Because we would have been out, but your lordship knows so many teachers going out is not a good thing either for the state or for the country.
So they have been protected and they should continue where they are.
And therefore, I only urge your lordships to consider whether this protection should come with offering something to me and then taking back an opportunity for lifetime, for future. Therefore, I will be stuck where I am. That's all I'm seeking your lordships to consider when your lordships take a final view. I'm deeply grateful, my lords.
Only I'll take 2 minutes, Lord. Oh, the idea of getting this training was to bring all these incumbents within the fold of the rules in questioning. And the fact of the matter is that once they have been brought within the fold of the rules in question, my lord, they stand on the same footing. As of today, my lord, in regard to the institution in question, it is true that it was a specific purpose scheme under which I got the training in question. But fact of the matter is, my lord, under the rules in question, as of now, I am to be treated as a duly eligible candidate in question. That is why, my lord, your lordship will kindly see that the central government, the Ministry of Home, at page 241 proceeded to write a letter to the council in question, my lord, asking them to consider the claim. And pursuant to this, the directive in question was issued, my lord. That letter is at page 241 and page 242, which clearly proceeds with, therefore, in this backdrop, it is required to issue a clarification.
41 of which matter?
It is the same states matter, my lord. It is at page 241 and page 242. It's a letter, my lord, request for TET DLD by Nios cleared candidates of Uttarakhand. It is by Ministry of Education, Government of India, my lord. Department of School Education and Literacy. Request for TET DLD by Nios cleared candidates of Uttarakhand state to allow them to apply for new vacancies of state teachers declared by the state in line of the state of Bihar. So this was a letter written by the central government, my lord, exercise of its power under section 29. I am directed to refer to a letter dated 16 November 2000 received from Uttarakhand Nios Teachers Association on the subject mentioned above. It has been requested that the teachers of Uttarakhand who have completed DLED course from Nios may be made eligible to apply for new vacancies declared by the state in lines of the state of Bihar. It would be pertinent to mention here that High Court of Bihar in so and so has cleared teachers working in government-rated private and school to allow for appointment as elementary teachers training degree will be considered as a recognized degree for the same. Further, the department and city accepted decision on Honorable High Court and decided not to file any appeal against this. Therefore, in this backdrop, it is required to issue a clarification to all states and UTs. Those candidates who have completed DLED course of Nios may be given opportunity to apply for fresh recruitment at par with other DLED candidates, subject to adherence to all other criteria and qualification requirements such as passing, TET, etc. So the central government has proceeded to write this letter, pursuant to which everything in question has been accepted, and even the state of Uttarakhand proceeded to accept the same. And subsequently, they have tried to rescind the same. This letter is very important, my lord, because it's a letter of the central government.
Yes.
And your lordship will also see, my lord, that to take a call on the question of equivalence, it is the competent authority is the NCT. The NCT has taken a call that it is equivalent. Once the NCT, that is the competent authority under the act in question, has taken a call, that your lordship will kindly find, my lord, where the NCT has been conferred with authority to take a call on the issue of, that is at page 104. Clause 5, interpretation. If any question arises relating to interpretation of these regulations or equivalence of various teachers training program, the council shall So once there is a directive of the central government, my lord, pursuant thereto, the council has taken a call. Pursuant thereto, my lord, the High Court has proceeded to pass an order that our claim in question, our candidature in question should also be considered. I submit, my lord, that once we are falling within the scope and ambit of the rules in question, because whatever rules are applicable, the institution in question wherein currently I am assigning my duties, my lord, they are covered by the same set of rules. In case I am not permitted to undertake any future exam, it will be blocking my road, my lord. So in that perspective, I respectfully pray, my lord,
There is no infirmity in the order that has been passed. That is all, madam. Obliged.
No, but whether NCT issued any communication after this?
Yes, they have issued a communication.
Where is this? Where is that?
I'll just
Page 250 members of the same essay.
page 250. Two 250, my lord. Dated 6 January 2021. It is addressed to the Chief Secretary, all state UT government as per list. The subject is validity of DOED program conducted by Nios for training of untrained in-service elementary teachers regulation. And the letter in question of the ministry is referred, and then this directive is in question is issued. And that is why the state of Uttarakhand proceeded to accept it, but subsequently, in their wisdom, they chosen to recall it.
Then why the regulation was not amended?
I am very thankful to my friend for point. 1 minute, Mr. Let him complete.
It was a decision of the government. The central government's directive is to be complied with by the council as per section 29. And that is what the council did, my lord.
See, when the field is occupied by framing a regulation, a statutory regulation, there cannot be any direction
Oh,
on the administrative side.
But it's not on administrative side, not the
It is
central.
administrative side.
The central government has taken a policy decision, my
It
lord.
would have. Central government should have amended the regulation.
It is the same central government that has taken a
Who
call.
stopped the central government?
At the first instance, my lord, certainly we were going out, so training was imparted. This is the second now model when fresh opportunity of getting employment, my lord, that has been blocked. That is.
Yes, you were saying.
Just a minute, Lordship may have the letter, my friend, I am very
May I seek
Mr.
your-
Shukla.
Yes, yes.
This letter of
Mr. Arora wanted to add something. You were saying.
6.
You are also appearing.
Yes. As per for similarly situated applicants, we were the original writ petitioners before the High Court. Now, by way of 3rd May order, your lordships allowed my statement. Because I am not going to trouble your lordships with the constitutional scheme. Knows that under list 3, education falls, and there is a central legislation which occupies the field. In terms of section 23, your lordships have seen all that. I will not repeat anything. I just wish to propound on 2 points. If in 2018 or 2019, I would have known that instead of this 1.5-year course, I had to do the 2-year course, I would have possibly left my job, done that and applied. I can only look up to one authority, and that is the NCT. I looked up to them. They said you are entitled to do it. I did it. I participated in it. That your lordships will keep in mind. Second, today there are 3 buckets of people that are before your lordships.
But NCT did it only with the direction of the pursuant to the direction of MHRD.
That's
only
right.
in order to protect your services,
That's right.
not for any other purpose.
But I would respectfully submit, that though this is the purpose that your lordships are interpreting it to be, but according to us, it entitles us to also, though that's an argument, it also entitles us to participate. There is no exception in that document for that. If I am entitled to hold on to a post, there is no law which can prohibit me to apply for it. Today, your lordships are sitting in a jurisdiction where my lords will decide fate of 3 classes of people. First are those, and this case certainly arises out of a fascination for government job. Please appreciate that. Today, there are certain set of teachers who are already in a government job. They are holding a post. They were also equally protected by this order. There are certain people, who will apply afresh. Certainly, they have to have that 2-year DLED course. No difficulty there as well. Third is our category, we fall in the private school. Now, if the interpretation that your lordships are proposing to accept is accepted, tomorrow, even for the existing government assistant teachers, there will be no opportunity without leaving their job, doing a 2-year course, then applying again. So what essentially is
if a government teacher who has got benefit of that scheme and has been
Kept in service.
Kept in service. And if there is any post for headmaster subsequently which requires particular qualification, then he will be debarred from that.
That's right.
The only purpose was to protect them so that they don't come on road.
I'm only placing for your lordship. Of course, we are at a position where we can only request your lordship to also consider our fate. Where of course, they would not sort of demote themselves from coming from government to private. But we are the only exceptional cases which are left out, who were told that, who were at least shown this hope of doing a 1.5-year course and then possibly be eligible to apply.
The only hope was shown was that if you do this course, your services will not be terminated.
Well, we took it, and rightly or wrongly, it was nobody who stopped us from it. We took it to be at par. Greatly.
Thank you.
Let me respond to his submission that he would have resigned and gone for the course. He was perfectly aware that this is a course, it's a program to enable him to continue. It was relaxation. This order was issued